Hello guys, this is a continuation of my series on payphones and privacy, which covers a court case called Charles Katz versus the United States. This was a court case that took place in the 1960s involving Charles Katz, who was a well-known sports bettor living in Los Angeles in the 1960s. This case had large implications on the Fourth and Fifth Amendments and the right to search, the constitutional protection of unlawful search and seizure, and affected many other cases and even overturned some cases. So this court case, so let me give you a brief description. So Charles Katz, a sports bettor, was in the 1960s was sending gambling handicaps, basically like I think it's like the over/under or whatever the odds are. I don't know much about betting, but he was sending this gambling information to bookmakers, to bookies in Boston and Miami in the 1960s, and he was using a payphone to do it. So this payphone was in Sunset Boulevard, very close to Katz's apartment. So the FBI began investigating Charles Katz, and they placed a covert listening device to the payphone in which they knew Charles Katz was regularly using. This payphone, and they placed this covert listening device without a search warrant issued by a judge of any kind. So what you might call legal search and seizure, although that law was not properly established at the time, at least as far as how it applies to what they might consider a public area. So so they got enough information. They recorded his conversations, and then arrested Charles Katz and charged him with knowingly transmitting wagering information from state to state via telephone. So Katz's defense first filed a motion to suppress evidence against him, which was obtained without a warrant, and this motion was denied. So then Charles Katz appealed to their conviction. So the court of Southern California, which he was tried in, they convicted him of these counts, and then Charles Katz's defense appealed this conviction to the Court of Appeals. I believe it was the Ninth Circuit. That was in 1966. The appeals court upheld the conviction because the device and search did not penetrate the phone booth itself, as in it was placed, this covert listening device was placed on the outside of the phone booth. So they said that they did not search anything or seize anything because this device did not penetrate the phone booth itself. And so the appeals court upheld the lower court's decision, and then Katz appealed to the Supreme Court, who listened to the opposing arguments. They took this case on, and they listened to the opposing arguments in October of 1967. And then that's where it gets interesting. So, sorry. Okay. So the appeals court, or the Supreme Court, once they took that and they let both sides give their argument, the Supreme Court came with a justice by the name of Potter Stewart. He was the guiding influence on the court's decision. So the court ruled 7-1 in favor of Katz, and overturned the lower court's decision to convict him of knowingly transmitting gambling information from state to state via telephone. So yeah, it was authored. The Supreme Court's decision was authored by Justice Potter Stewart, and the consensus essentially was that the Fourth Amendment, which is the right to the protection from unlawful search and seizure, that this Fourth Amendment protects people, not places. As in, it doesn't matter whether you actually break into a place or penetrate a place. If the place or the information being sought is if it's, it's protected. The Fourth Amendment protects the information from being taken by the person who, it protects the person whose information is being searched or seized, not the Fourth Amendment does not protect the environment, the space, the facility, whatever houses the information. It's not protecting the building or house of the information itself. It's protecting the person whose information it belongs to and of whom is being investigated.